Adoption for any any trend the office of the special prosecutor ebe kind because ene no share that say Ofori Atta the ambition 1-on-1 busan 5 questions na so with me answer nyina na ni huso dia no go to back to UK and as in the United States of America be on ankasa no na go enjoy the life because right now I'm gonna for here accountability including office of special prosecutor Kissi Agyabeng no ono so ehia accountability near maybe why yan ni kwanse oye nyina no so oyere ope na so okache ken of Atta no den semi ni wano oh me yale and ebe message that say afide dbl seji den dru as yanye ene ya catch us bra o catch OSP say untimi mba na the Indian timba ne say we are anymore then the way in our question on the 13th of June. The after that, no rest be one answer no about. And yes, I did on no a video. We announce a video call and as a Zoom. No, me don't be a question, but so be civil. It also shows be a channel too. And I see a jail and I said, Nako court in tea. On Besol in Honka Bene, a back a year Ghana Campo. Or some Besol Bagana Campo. Indingebe and communion video call no mon kasani ade eno na officer of special prosecutor ne about WڃNTEİ may update just say or can say any both ye pan or kasana say those na or kasame yare ne ade no medical report be on the table so then our country gonna for nyina say we declare Fata wanted again. Now I sending a year for meet my me Interpol meet my arrest a kind of Fata any many ya in the Newz we are there kind of Fata time will be driving you by the because near my question will be a accountability or a community a OSP eba they then come out to us.
Prosecutor. His lawyer stated further that in order not to hold the office back in the performance of his function, they had Mr. Ofori Atta's instructions of his readiness to go through video recorded interview for the purpose of eliciting his caution statement. His lawyers offered to meet the special prosecutor in person or approach the bench for the purpose of viewing Mr. Ofori Atta's biopsy report, whichever suited the special prosecutor. Now, ladies and gentlemen of the media, this is where we are now. And let us step back a bit from the 28th May 2025 letter from Mr. Ofori Atta's lawyers and place the matters in their proper context. I have intentionally went through a tedious timeline. The letter from Mr. Ofori Atta's lawyers, dated 18 February 2025, clearly indicated that the possible surgical intervention to be performed on him was to occur on 20 and 21 March 2025, upon which reckoning the OSP carefully considered the recovery period and indulgently pushed Mr. Ofori Atta's attendance at the OSP to 2 June 2025. Therefore, Mr. Ofori Atta had a duty to promptly inform the OSP of any fundamental change in his medical circumstances on 21 March 2025, when the advertised surgical intervention was not performed, to enable the OSP reschedule a new date of his attendance at the OSP to accommodate any such material changes in his medical condition and treatment itinerary. Mr. Ofori Atta has known, at least since 21 March 2025, that no surgical procedure was to be performed on him in March. Yet, he purposely sat by indolently and chose not to inform the OSP of such fundamental changes in his to the 28th May 2025 letter from the lawyers of Mr. Ofori Atta. As I said, this is where we are. By a letter dated 30 May 2025, the OSP declined Mr. Ofori Atta's offer of video recorded interview for the purpose of eliciting his caution statement. This office has always insisted on his personal attendance, and we have indicated clearly to him that we are unwilling to waive it. If we were amenable to taking any such statement from Mr. Ofori Atta in absentia, we would have done so in February and not waited to 2 June 2025. We want him here physically, and we insist on it. A suspect in a criminal investigation does not pick and choose how the investigative authority should conduct its investigations and the method suitable to him and his convenience. We will not countenance such conduct, not in this case or in any other case. Further, the OSP has declined Mr. Oforiatta's invitation to view his biopsy report as we consider it a pointless exercise. This is because it is common learning that the biopsy report contains nothing more than a conclusion upon the removal and examination of tissue, cells, or fluids from a living body that some disease or malady was indicated in the samples taken. A biopsy report is not an expression of a reasoned medical opinion that the subject of the report is an invalid and unable to travel, as Mr. Oforiatta seeks to suggest is his condition, and for which reason he says he cannot return to the jurisdiction. This much is clear. Since 24 January 2025 till date, Mr. Oforiatta has failed to show any medical report. I underline, he has failed to show any medical report which suggests that he is a travel risk and unable to return to the jurisdiction by reason of his medical condition. It has all been his say-so, his singular say-so. Therefore, the OSP views Mr. Oforiatta's lawyer's letter dated 28 May 2025 as an expression of utter bad faith on the part of Mr. Oforiatta, and it confirms our long-held, well-considered opinion and conclusion that Mr. Oforiatta has no intention of voluntarily returning to the jurisdiction and to attend the OSP. Further, this office is unaware of his purported information to the OSP, and Mr. Oforiatta failed to attend the OSP today. Mr. Oforiatta's conduct is totally unacceptable and a baleful spite at law enforcement and criminal investigations. It ends here. It ends today. We will no longer accommodate him. Consequently, the OSP redeclares that Mr. Oforiatta is a wanted person and a fugitive from justice. His name is hereby re-entered on the OSP's list of wanted persons. The OSP will take all necessary legal steps to secure Mr. Oforiatta's return to the jurisdiction and to answer to the criminal inquiries against him. In pursuance of this, about 30 minutes before this briefing, I triggered processes for the issuance of an Interpol red notice for the location and provisional arrest of Mr. Kenneth Oforiatta, pending extradition or his surrender. Around the same time, I dispatched a request for extradition processes to be instituted for the provisional apprehension in any jurisdiction to the Republic of Ghana. The OSP will prefer criminal charges in the courts against Mr. Oforiatta in due course, whether in absentia or otherwise. The principle upon which we proceed is that no person, regardless of title, regardless of status, regardless of medical, is beyond the reach of inquiry by the OSP. Thank you. The OSP had commenced investigation into suspected corruption and corruption-related offenses regarding cases in respect of which the OSP considered him a suspect at the time. By a letter dated 31 January 2025, Mr. Oforiatta informed the OSP, through his lawyers, that he was out of the jurisdiction indefinitely on medical grounds, and that the firm will notify the office of his arrival in the country in aid of rescheduling his personal attendance at the OSP. Further, the lawyers offered its willingness to provide the OSP with any information we may require to aid in the investigation until his arrival in the country. Upon receipt of these representations from his lawyers, the OSP, by a letter dated 5 February 2025, informed Mr. Oforiatta that the OSP did not need or required notification from his lawyers of his future arrival in the jurisdiction. The OSP acknowledged his lawyers' offer to provide us with information in aid of the investigation. However, the OSP insisted that his personal attendance at the OSP was required. The OSP directed Mr. Oforiatta to indicate by close of business on 10 February 2025, is returned to the jurisdiction and attendance at the OSP. The OSP warned him that if he failed to do so, the OSP would take all necessary legal steps to secure his return to the jurisdiction and attendance at the OSP at our own choosing. Mr. Ofori failed to indicate a reasonable date of his return to the jurisdiction upon the expiry of the 10 February 2025 deadline, except to still persist in his expressed intent of remaining indefinitely outside the jurisdiction by the transmission of his lawyers of a purported and brusque medical letter on 10 February 2025, which only sought, in effect, to state that he may undergo a possible surgical intervention in March 2025. In the considered opinion of the OSP, that medical letter could not be held to be a disclosure of a reasonable date of Mr. Ofori's return to the jurisdiction and attendance at the OSP, since it merely indicated that there may be a possible surgical intervention that may or may not occur in March. The letter, which was in no way a medical report, neither stated nor demonstrated that Mr. Ofori was a travel risk or that he was an invalid who needed around-the-clock intense medical attention to the point that traveling to the jurisdiction would endanger his life. Remaining indefinitely outside the jurisdiction, without indicating a reasonable time of his return to the jurisdiction, showed clearly that he had no intention of voluntarily returning to the jurisdiction. By a letter dated 17 February 2025, Mr. Ofori's lawyers transmitted to the special prosecutor a communication laced with vituperation and designed variously as a denigration of the OSP, a lecture on their suppositions as to the mandate of the OSP, a threat of legal action, a sort of homily as to how the OSP should conduct its affairs, an attack on the person of the special prosecutor, and a suggestion that the special prosecutor had embarked on a personal vendetta against Mr. Ofori, without disclosing the alleged series of retaliatory, vengeful, or hostile acts the special prosecutor had directed at him, or alleged exchange of such acts between Mr. Ofori and the special prosecutor. Crucially, a 17 February 2025 letter from Mr. Ofori's lawyers failed to indicate a reasonable date of Mr. Ofori's return to the jurisdiction and attendance at the OSP. On this reckoning, the OSP, by a letter dated 17 February 2025, reaffirmed and restated to Mr. Ofori that he remained a wanted person and a fugitive from justice. The OSP further stated that this tag will so remain until he indicated a reasonable time of his return to the jurisdiction, with the necessary and reasonable assurances of abiding by his indicated reasonable time, or until such time that the OSP enforces return to the jurisdiction and attendance at the OSP, whichever came first. By a letter dated 18 February 2025, Mr. Ofori's lawyers communicated to the OSP that he was scheduled for a possible surgical intervention in the United States on 20 and 21 March 2025, and further that, taking the date of the possible surgical intervention into account, he would require a recovery period of 6 to 8 weeks. On this basis, his lawyer stated that he should be able to return to the jurisdiction between 14 and 30 May 2025. On the same day, by a letter dated 18 February 2025, the OSP graciously acceded to Mr. Ofori's request to return voluntarily to the jurisdiction between 14 and 30 May 2025, as the office deemed the indicated recovery period reasonable in the circumstances. Consequently, the OSP removed Mr. Ofori's name from the list of wanted persons pending his voluntary return to the jurisdiction based on his own indicated that if he failed to voluntarily return to the jurisdiction within his stated dates, and if he failed to attend the OSP on the rescheduled date of Monday, 2 June 2025 at 13:30 GMT, his name will be re-entered on the list of wanted persons, and the OSP will consider him a fugitive from justice, whereupon the office will take all necessary legal steps to secure his return to the jurisdiction and attendance at the OSP at our own choosing. Then, by a letter dated 28th May 2025, Mr. Ofori's lawyers informed the special prosecutor that a medical expert has diagnosed Mr. Ofori with cancer and has earmarked 13 June 2025 for surgery, for which reason he would be unable to return to the jurisdiction as scheduled. His lawyer stated that to the knowledge of the OSP, this change in circumstances has been brought to the attention of the court, before which Mr. Ofori is presently pursuing a human rights claim against the OSP and the special prosecutor.
Abusian for any attensema a year office of the special prosecutor Kesi Agyabeng at the two judges and Nyasam Gatua. And Nibiswana a year OSPD Casano na like a Nyasam Gatua because any braba yes ye accountability ya tonsa fra we him say now more bem ya na mo yare ne o yare ne ade tim ko hwe ho na o kidney ne ade obia tan ase but baby edu ne si hia wo abusibisa wansem on fa medical report bia by mechese ampani empire kwa ko yoseji na niema de benyina and reason de benyina say be pointless. That means say like a make any sense to a OSB enti and now the medical hospital akwa message ye the medical to date we now to OSB ha and watchina sa na wase bra wa WhatsApp the catching say nkibe ya omonye ne Zoom because omase on rest no se na be beti makọ a hospital on the 13th of a year this month so beti makọ a surgery na kan so be March mu no odi ade ne be she May obi ate ase na mini drawamba odo a second June se bra wo ka chen se omansanye no a video conference and as a bia a Zoom and I bisa now the net draws one zamba watch the wope no one said tamay kwa of vetting company on our check data wope and your committee no date no the by one our check data wope to idea we like intending and night ama OSP idea committee akaze is no oka wanted list na ashia taking it say or say Interpol no more a year baby or say USA UK no or more arresting on funny the funny see plane on funny by see in the as we speak right now and after 2 we declare a year one a kind of Fata wanted no actually take it over baby one and kasanga say no ne ho hye pa because so also I am pampa then a video we ba bonti and circulate almost am penimpa na did your restaurant ya dia na was no ma bibia nyawo bibia nyawo browse me ma na o ye dia wope Ghana for injimisa Ghana for injimisa Ghana for in accountability bla cheche mu che o tutu nipa ene o chena on fa for mo eda yoko question o cha mo ana o fa edu boy o chena na asede obia e business mo intime ya no with a year legit a year reason about a scandal be a PPA and then will be facing the law say we go to after court said we will demo ni nyina no. It depends on how you are going to explain things to a year or more mudini many more Ghana say Attorney General a year officer special prosecutor Kesi Agyabeng. It will be a example and pano beden ubeba wamba and a bugana in tia and now for Ghana for so she and our turn out to me COB so no declare wanted and I say declare wanted I could see ne Faneko court Nekona could see in the I didn't know one declare wanted. They may be a question like even then time now a finance minister company na MPs for ni be egg and jack of others on winning free because of Niema na into na MP for ni become MP. Then they were free na ni maybe why is baby ya no so one back. I know and a year OSP and the home tiakas or declare wanted. Or more okay can bit my actually had your comments with share more than for saying I have for 1 Akroma.